All right, a federal judge just ruled that Texas's anti-ESG law is unconstitutional. I know that sounds niche, but it has real implications for free speech and a wave of similar laws we've seen across the country over the past few years. So please, even if you're not in Texas, just hang out for a minute. Now, before we talk about the court ruling, we need to be clear about one thing up front. What is ESG? Because without that context, none of this is going to make sense to you. ESG stands for environmental, social, and governance. At its core, ESG is a set of principles and practices that help companies and sometimes investors think about long-term risk and responsibility. Environmental is related to things like climate exposure, pollution, toxin and material regulations that essentially could affect a company's bottom line or their ability to do a certain kind of work. Social covers the people part, like labor practices, worker safety, supply chains, whether companies treat workers fairly. And governance is about how a company is run inside. So that's things like executive pay, corruption, fraud, shareholder rights, mechanisms of like internal accountability. So investors don't just blindly follow ESG. They use it as one lens among many to understand risk and long-term stability. Companies may also use ESG principles to guide their policy, their reporting mechanisms, and their shareholder engagement. And many large F100 and F500 companies have entire departments dedicated to just ESG, and there are think tanks and consultancy firms that focus on those issues solely as well. And in full transparency, I used to work for one. The point is, ESG isn't a law or a mandate. It's a set of principles that provide a way of thinking about what might affect a company down the road and what impact that company has on things like environment and people. So now here's where Texas enters the picture. In 2021, Texas passed a law called Senate Bill 13, or SB 13. Now you know what SB stands for. The law barred the state essentially from investing public money, so things like teacher and state employee pensions, with financial firms that were boycotting fossil fuel companies. It also required that the state comptroller create and then maintain a blacklist of firms that the state deemed hostile to oil and gas, and then to divest state funds from those firms unless those firms agreed to change their position on oil and gas. Now, this week, a federal judge, a Trump appointed federal judge, ruled that law to be unconstitutional, and not in a small way. The court found that SB 13 violates both the First and 14th Amendments because it allows the state to penalize companies for protected expression, in this instance related to fossil fuels. The judge also ruled the law was overly broad, meaning it swept in a wide range of very lawful and protected activities and gave the state way too much discretion to punish companies based on viewpoint. So that matters because the Constitution doesn't allow the government to use financial pressure to enforce any sort of ideological alignment. That the government cannot say, we love fossil fuels, and because you don't, we're going to blacklist you. The ruling is especially notable, I think, because it doesn't hinge on any sort of technicalities in the law. It addressed the core mechanism of the law itself, the use of blacklists and divestment to coerce private actors into adopting the state's preferred economic and political positions. And it's not just a Texas issue. Over the past several years, if you pay attention to that space, multiple states have either passed or tried to pass anti-ESG laws that restrict public contracts and investment based on things like whether firms consider climate risk, labor practice, or corporate fraud to be concerns. This decision doesn't automatically invalidate those laws, but it gives a strong constitutional framework for challenging them. If a law punishes companies for expressions, their viewpoint on social issues, or using a lawful risk analysis rather than regulating actual misconducts, that law is on shaky ground. There's also a practical issue here that I think will get buried, and that's public pension. So if you don't know, public pension funds exist to protect retirement security for people like teachers, firefighters, police, state employees. When states impose ideological constraints on how funds can be managed, they undermine the fiduciary responsibility and long-term financial stability of those pension funds. Courts are becoming increasingly wary of laws that try to subordinate pension management as a form of kind of manipulating political agendas. So zooming out, this ruling is a reminder that states don't get to decide if risks are real by legislative fiat, and they don't get to punish ideological or belief disagreements by weaponizing public money, because that's what happened here. The Texas state government said, we are super pro fossil fuels, we're super pro traditional oil and gas sector, It brings a whole lot of money to our coffers, and we are lobbied by a ton of these companies. And therefore, if you think you're going to use any sort of state resources for the benefit or success of any company boycotting those industries, then we're going to essentially blacklist you out of our state. It's not allowed. Now, Texas said in the reporting that I looked at that they will absolutely appeal, and they will, but that doesn't matter because for me, the precedent set is clear. The court says if a law relies on ideological blacklisting and viewpoint punishment, they will face serious constitutional limits. So let me know what questions you have about this, if any, if you were following this piece of legislation, and if you know anything about ESG, because I think it's a fascinating topic and it may seem boring, but would love to talk about it more.